and that of Labour Party Peter Obi, affirming the election of President Bola Tinubu. TVC News reporter Celestina Ria reports.
There must be an end to litigation, and this is the end for the appeal filed by Labour Party and its presidential candidate, as well as the PDP and its presidential candidate, as the Supreme Court is the final arbiter. Of course, our justice system says he who alleges must prove, and today the Supreme Court held that the Labour Party and the PDP failed to prove all the allegations they have made against the president's victory in the last presidential election. Firstly, the court ruled on PDP's interlocutory application to bring in new evidence to prove its case against the president. The evidence was President Tinubu's Chicago State University certificate, which they had obtained from the US. The court held that it cannot be assumed that jurisdiction can be conferred on the court by parties. The court cannot invoke Section 22 of its Act after the 180 days for the trial court to deliver judgment has lapsed. A petitioner cannot amend its petition after the 21 days allocated for filing petition has lapsed, in line with Section 134 subsection 7 of the Electoral Act. The court subsequently declined jurisdiction and dismissed the application. In the main appeal, the court held that a petition seeking to nullify an election on grounds of non-compliance must establish it. The appellants abandoned their duty to prove non-compliance. They relied solely on INEC non-transmission of election results real-time. The failure of IREV does not stop the collation of results. The unavailability of election results on IREV cannot be a ground for which an election can be nullified. On the issue of 25% of votes in the FCT, the court held that there is nothing wrong with the Court of Appeal's decision on this issue. On the PDP's allegation that the president did not win 22 out of the 36 states, the court held that they failed to produce alternative results. The Supreme Court adopted the position held in the appeal filed by the PDP in the appeal filed by the Labour Party. Both appeals were dismissed for lacking in merit. Celestina Ria, TVC News, Abuja.
And moments after the judgment, the president said the Supreme Court judgment has strengthened his resolve to do more for Nigerians. The president, who received several dignitaries at the presidential villa, also stressed that Nigerians have no other country and must work together to ensure that the country gets better. The 7-member panel led by Justice Iyan Okoro earlier today dismissed the appeals filed by the People's Democratic Party and the Labour Party for lacking in merit.
I've started from day one to work hard, regardless of, the court cases, okay? And just strengthen my resolve to do more. A challenge of this nature and a future of this nature is more work, and more hard work, more dedication. Just appeal to the sense of patriotism of Nigeria to have a change of mindset. Let us be positive about our country, be ready to contribute in all ways possible. There's no promise of El Dorado from day one. We're all in this boat of diversity, a member of the same family, living in the same house, but stay in different rooms. And it is important that we recognize that we have no other country but this one. So we better be committed to it, not for the sake of our own self-aggrandizement. Our commitment to the values, the creed of dedication, patriotism, and commitment to the value of this country.
Such a happy day for the president. Meanwhile, former President Muhammadu Buhari has welcomed the Supreme Court's verdict that upheld President Bola Tinubu's election. He's also asking the opposition to team up with the president to build the country. Buhari made this known in a statement after the Apex Court dismissed appeals by Peter Obi of the Labour Party and the People's Democratic Party, Atiku Abubakar. He noted that the judgment is a welcome relief to him and the majority of the citizens of Nigeria. Let's take a short break, and when we return, it will be time to speak with our guest of the day, a lawyer, Omori Edogawere, and the ADC candidate of the 2023 presidential election, Kachukwu Dumebi, for discussion on the Supreme Court affirming President Bola Tinubu's victory as the president of Nigeria. Please stay with us. Welcome back. You're still watching Politics Tonight, digging beyond the headlines. Now let's get to our interview with the guests of the day. I am joined by a lawyer, Omori Edogawere, and the APC candidate of the 2023 presidential election, Kachukwu Dumebi, for discussion on the Supreme Court affirming President Tinubu's victory as the president of Nigeria. Gentlemen, thank you so much for joining us on Politics Tonight.
Thank you for having me.
Right, so a journey that started on the 25th of February has now ended with a unanimous judgment by a 7-man panel of the Supreme Court justices. You're a lawyer, so let me start with you. What's your view about that judgment?
Well, I think that it clearly has addressed certain issues that have been nagging our minds. And the beauty of case law and judicial authorities is that what it does is that it sets certain precedents that other courts can now follow. I was here a few weeks ago when they filed, and one of the things I raised at that time was that it's good for our electoral jurisprudence that the matter gets to the Supreme Court and that certain things are addressed. For one, the ruling, the judgment on the FCT clearly has put to rest whether or not the FCT enjoys a special status, whether or not that 25% is a condition precedent for victory. And I think that it's good for electoral jurisprudence that these issues have now been addressed and put to rest. Regarding the decision of the court, I did not expect the court to go otherwise. And any lawyer who clearly understands our electoral jurisprudence and the fact that the courts operate by rules of courts would know that if this decision had gone otherwise, I think it would have maybe been a deviation from the precedent that are set down. But what are the lessons to learn from this? What are the things to look at? I believe that, like the court said, and one of the things I enjoyed in that, listening to that judgment was that there must come an end to litigation. So we must now, the courts have ruled, the Supreme Court has ruled, this matter has been put to rest. What are the lessons to learn, both for INEC, both for the political parties, both for the institutions of government, both and most importantly for our electoral process. It only shows that there's work to be done. We need to go back to tidy up a few things, to clear certain ambiguities, and most importantly, to learn from our mistakes here so that we can improve the process. Nigeria, our electoral process remains a work in progress. And just like this clearly show that we're on our way. We may not be there yet, but we're definitely on our way. Having run successive, democratic dispensations back to back, shows that there's something we're doing right, but there's more to learn. And with this judgment, I think that everybody has gotten their knocks. In particular, the court clearly said that even though uploading real time to the IRF portal was not, fundamental, and the failure to transmit cannot be said to defeat the legitimacy of the elections, but that the INEC's breach of that promise, raised certain public concerns that, affected the acceptance of the result. So INEC should take that feedback very, very closely and ensure that when they make certain commitments and promises, they keep to it. And if for any reason they cannot keep to it, there's a better way to express or report back this issue.
So for the past few hours since this judgment was delivered, there have been talked about the enormous lessons that every stakeholder has to take away from that judgment? And we will take them distinctively in the course of the program. Mr. Dumebi, let me come to you. Now, while you react to the outcome of this judgment, what aspect of this judgment do you consider as most instructive?
I think the lawyer touched on it briefly, and I think the difference between what the Presidential Appeal Tribunal did and what the Supreme Court has done today is that the Supreme Court rebuked INEC in failing in some of its responsibilities, which has led to the situation in the body politic today. I think so. That I have always called for this. I have long said that whereas it was clear that the APC genuinely won the elections, but because INEC failed in its duties, Nigerians have called into question that election. So I felt that INEC ought to have been called out long ago. The appeal tribunal failed to do that, but the Supreme Court has just done that. But again, we also have to, in looking forward, hope that we don't see the kind of gangsterism and rascality of political parties in pursuing their mandates, because what we've seen in the last couple of months is just sheer rascality on the part of these parties. We saw that in presenting their cases before the court, that they didn't present any substantial case concerning the election itself and showing that they won the election. They were unable to do that. They knew they were unable to do that. So they knew ab initio that they didn't win the elections. So all they sought to do was tarnish the image of the institution, the process, the president of the country, and also bring Nigeria to a near state of anarchy. They brought Nigeria to the brink, to the precipice. And this should not happen. Politicians should show statesmanship. Should have sportsman conduct. You know, you don't expect that you will win every election. So a situation where you carry people, the emotions of people, give them false information, let them feel that something is about to happen, raise money from unsuspecting members of the public, knowing inside you that what you're doing is absolutely wrong, that there's no basis, no foundation for what you're doing is clearly wrong. That's why I call it rascality and gangsterism. Our parliament, the National Assembly, should now look at what they can do to ensure this doesn't happen again. We are fortunate as a people, as a country, that Nigeria did not burn. But you can see once the judgment was read out today, common sense judgment, all Nigerians were settled. I mean, all the people felt Nigeria was going to burn. And once the judgment was read, it was common sense. You saw all the elements of law. You saw all the elements of the argument. The judges were very, very clear on that. Nobody had anything to say anymore. I listened to the Labour candidate spokesperson who was saying that they are appealing to the court of public opinion, and I laughed. Since the beginning of this, all they did was appeal to the court of public opinion to bully the judges. That's all they have done. Now the Supreme Court has ruled, and you still say you're appealing to the court of public opinion to do what? To go out on the streets and burn Nigeria? We need to put a stop to all this rubbish.
All right, Mr. Mori, let me come to you. I mean, he's spoken about the lessons for his fellow politicians. But for you as a lawyer, did you think the lawyers did a terrible job?
That would be anybody who says that any of the lawyers on all sides of the divide did a terrible job would be uncharitable. In providing professional advice to your client, oftentimes you view it from your own lens and within the ambit of your own knowledge. I wouldn't want to speak to the competence of any of the lawyers. And all the lawyers across board are all eminently qualified, leading lights in the legal profession. And we will say that indeed we are proud of them, both the lawyers to the respondents and the petitioners. But let's look at the major issue, which is the frontal attack at the institution called the judiciary, and how these elections and election petitions flowing from it have frontally attacked. We saw for the first time in our lives that photographs of justices were published and with quotes. But I must commend the judiciary for standing by the rules upon which it is built. and sticking to the rules and not pandering to the intimidation of those who see things from their own lenses. If there's anything that has come out today, is the fact that voter education is fundamental. So the journey to an electoral process is one that must start at the end of every electoral cycle. We must now begin to teach people that there are rules and there are certain procedures that must be met. If you recall the last time I was there, I gave you an analogy and I said, look, to come into your studio, there are conditions precedent that must be met. I remember. Right? And so people must now understand that judgment, the decisions of our court are based on certain rules. I gave a hint when I spoke earlier. I said, look, we now need to go back to the drawing board. The active actors in the electoral process must now say to themselves, in the light of the 2023 election, is the electoral act we have today fit for purpose? Do we need to amend certain things? Do we need to clarify these issues? And do we need to pass across this information to the voting public so that the young man who sits down there and vilifies a justice of the Supreme Court or a justice of the Court of Appeal because he has limited information is now informed that there are certain rules. The rules of evidence are clear. The procedures are clear. Have the parties met this procedure? Have they fulfilled this condition precedent? You know, and I think that with improved voter education, we will begin to have, you know, a more conscious approach to some of these issues. All right. So I must commend the judiciary for standing firm on the rules upon which it was based. All
right, so I asked the question because some of the justices, according to the justices, some of the petitions were considered as abuse of court processes. And according to many, these lawyers should know better. But let's look at one key aspect of this appeal, which was Atiku's effort to bring fresh evidence in his appeal, which the Supreme Court rejected. Did you see that coming?
Yes. Well, so the thing is, I like to speak from a place of superior opinion, and that would be after one has reviewed in hard copy the decision of the court. But strictly speaking, on appeal, can you bring new facts? It is elementary law that you cannot adduce new facts on appeal. Appeal is based on points of law and areas where you believe that the Court of Appeal has erred. And so you cannot bring fresh facts. Emphasis on the word fresh facts. So I think that it was a no-brainer that the court would have addressed it that way. Does that remove the place of critical and jurisprudential thinking? Like I said, lawyers see things and represent clients within the ambit of the rules of court and the judicial precedents and laws that are before them, but also sometimes attempt certain judicial latitude, you know, to impugn certain things. But I think that the court was on all fours to say, look, this is our new facts. You cannot bring them in.
Mr. Kachuku, let me come to you. The Supreme Court also ruled that this so-called deposition from the U.S. cannot be admitted because, I mean, it was not properly obtained. What's the implication of this?
No, I think Supreme Court, what Supreme Court was clear on was the fact that you cannot at this late hour be introducing new or fresh evidence. I think that's the case the Supreme Court was clear on. I also believe that looking at the caliber of lawyers on both sides, that it was funny, let me use the word funny, that any of them thought that it was actually possible for that to have been done. They all knew that there was absolutely no way the Supreme Court will have allowed that. They all knew that. So I don't know why they even attempted it. It made no sense to me.
Right, so this matter of 25% of votes in the FCT is another issue. What's your view about it?
Well, again, it's common sense. I don't believe the framers of our Constitution ever expected that residents in any part of Nigeria will have more rights than those in other parts of Nigeria. That could never have been their intention. Obviously, as you know, with lawyers, any lawyer on any side will try and make an argument to support his case, even though the common sense approach was clear to all Nigerians, to all lawyers in that court. They all knew that it was very, very clear that the framers of the Constitution did not intend or propose that Abuja residents will have a right superior to the rights of those in Lagos, Ogbomosho, Ekiti, Abia, Imo, Nasarawa, Kefi, anywhere, you know. The framers of the Constitution never intended that, and it was very, very clear. And I'm happy that the Supreme Court has laid this to rest, so that Nigerians are all clear. Because sometimes when you hear the passion with which people argue this, that Abuja could decide the elections, I just wondered how. But again, like the lawyer has said, we ought to start now educating the populace. They need to understand all the issues, understand the laws, understand every single thing, because it's very easy to lead a gullible people and ignorant people astray and thus end up burning the country.
All right, so the Supreme Court, I would like to, before I go on with my question, I would like to have your take on this matter of 25% of votes in the FCT.
Well, like the court have said, if the framers of the Constitution intended to ascribe special status to the FCT, they would have expressly done that. And the court also gave a hint that we all lawyers must now take, that in seeking to interpret sections of the Constitution, the courts must be very wary of adopting a narrow, rigid approach. Right? And it's very clear that matter, for me, I'm very excited. And the reason for that is that it will put that issue to rest in finality. Right? The FCT does not have a special status. The Constitution counts the FCT as a state, just as it counts the other 36 states in deciding the two-third majority, and nothing more.
So with the way Mr. Kajiko has called some Nigerians gullible, who do we blame for anyone to have thought that Abuja is superior to any other states? So
you look at we're in a digital age. So I'm a tech and startup attorney, and we deal with technology, right? And so we're in a digital age where someone can sit down, and because you have a large following, post a tweet, and everybody who follow you believe that, right? So, and that's a challenge. There's so much information, so much half-baked, false and misleading information out there, not just in the electoral process, but in other sectors. So I think that's why it's important that government must now also amplify its voice, right? It's not enough to take certain things for granted, right? It's important. You see, this is where I ask, where is the place of the Nigerian Orientation Agency, if they still exist, right? Where is the place of these agencies of government that are supposed to actually clearly state some of these things? INEC also must play a pivotal role in voter education. Like I said, the journey starts now. Begin to tell people, explain the Electoral Act for dummies, right? Simplify it, right? You know, so when you want to simplify a document or a simplified document, you say XYZ for dummies, right? So make it very, very, very simple that everybody understand. Convert it into transcribe it into all the languages in this country, spread them across, and begin to explain the electoral process. For players in the electoral process, both the civil society and political parties, it's time to sit down and say, let's look at this electoral act. Like I said, is it fit for purpose today? Are there things we need to amend? Are there issues that we need to discuss? For constitutional lawyers, if they believe that the Constitution has gotten into a time where certain parts of the Constitution should be amended, then that conversation must start. Elections have come and gone. The electoral jurisprudence, the electoral judicial proceedings have also come and have now gone. Governance must now begin in earnest without any distraction, and we must now again prepare for the next 4 years. How do we do that? Reorientation starts now.
All right. Gentlemen, that's another key element of that judgment is that the Supreme Court upheld the decision of the appeal court, the IRF cannot be used as collation center for election results. Mr. Kachuku, let me come to you. Why did the petitioners and their lawyers fail to do the needful about presenting results before the court?
Well, I believe that that is the hardest part of a lawyer's job in gathering relevant facts, gathering evidence, especially when there's no evidence to gather. That was the hardest job for the lawyers who took this case to the court. How do you gather something that is not there for you to gather? And since there was nothing for them to gather, they then looked at technicalities. And on social media and the court of public opinion, everywhere they went, they pushed technicalities, they pushed hearsay, they pushed rumors, because there was really no evidence to gather. Gathering evidence, it means that wherever you have alleged, you must then substantiate. You must show the facts, the hard facts, to substantiate what you have alleged. If you say that you won in this place, show the proof. They could not do that. They knew they could not do that. It was very, very clear to them from the beginning. And so they sought to just focus on the fact that INEC had technical issues. They sought to focus on other technicalities, all in a bid to upturn the elections, because they knew that on the hard fact of did you win this election, it was clear that they did not win. But again, it brings us back to what lawyers seem to have alluded to when you talk about amending the Constitution. We can keep on amending the Constitution. It will never be so much about our Constitution, but it will be about the people who are implementing the Constitution. We are here today. Nigeria was on the precipice because INEC in some areas failed in their responsibilities. I listened to the president's speech today. A great speech. But I believe that if the president had just made one extra pronouncement relieving the INEC chairman of his duties, Nigerians would have applauded him today. Because in reality, the fault is not the president. The fault is the fault of INEC. And the INEC chairman ought to take responsibility for failing Nigerians, considering the enormous resources that was allocated to INEC to conduct the elections. That's why we're here today, speaking about this. So we can amend the Constitution again to make it easier for INEC to conduct elections. Whatever you do, as long as you have the human element that is prepared to undermine that process, you will keep on coming back to this situation where whatever we do when we go out to vote, the courts will keep on being the actual voters in the election.
All right, gentlemen, let's take a break. I've been speaking with ADC presidential candidates in the 2023 presidential election, Kachuku Dumebe, and a lawyer, Omori Edogiawere, tonight to discuss the Supreme Court affirming President Bola Tinubu's victory as the president of Nigeria. We'll take a break and I will be right back. Please stay with us. Welcome back to Politics Tonight, and if you're just joining us tonight, we're discussing the Supreme Court affirming President Bola Tinubu's victory as president of Nigeria. And I've been speaking with the lawyer, Omori Edogiawere, and the APC candidates of the 2023 presidential election, Kachuku Dumebe. Gentlemen, now before we went in that break, let me buttress Mr. Kachuku's submission. The appellants made a case for voter suppression, and it was struck out by the Supreme Court. I mean, evidently this judgment is a lesson for all politicians. But for you, how important is or crucial is the role of polling unit agents? Well,
I'll respond with a popular quote in law, that he who asserts must prove. If I say something, I must back my statement by proof, with the requisite proof. And like I said, dissecting court judgments is not one that you do in a flighty manner. But for the sake of information, especially for the public, it's important that they understand that the failure of the petitioners lay strongly in the fact that they were unable to prove their case as far as those polling units were concerned. And the Court of Appeal gave a very clear, concise breakdown of how they have failed to do that, right? So if you say you won in TVC Studio 1 and you were disenfranchised or your results were changed, you've got to prove it, right? One way of proving that is having a polling unit agent come and give direct evidence to say, I was there, I saw it. Any other thing would be hearsay, right? And in evidential rules, that automatically has its shortcomings. You know, hearsay evidence does not carry as much weight as direct evidence from the actual participants in the action. So, you know, those are some of the things. And they relied heavily on INEC and INEC's inability to transmit. And, you know, that's reduced the potency of their case. But the courts clearly have stated it. So we've learned, what are the lessons to learn from there? You know, learn those lessons and move on. But we must not now forget the place of public opinion. We must not now forget the place of social media. We must now realize that we are now in an era where even social media has the capacity to make its own rules, to create its own principles. And if the institutional established principles are not clearly explained, impartially enforced, these public policy principles and social media rules will, you know, they could be like weeds. You know what weeds do to the actual crop? They outgrow the crop and kill the crop. And so you must now have an intentional flow of information to weed out information such as this.
But how shocking is it for you that Labour Party calls this a hijack?
The Supreme Court judgment?
Absolutely.
Well, I wouldn't want to. I'm a lawyer and I'm a minister in the Temple of Justice. And I am under oath to respect the institutions that I belong to. I have listened to the judgment. I have read the Court of Appeal judgment. I have listened to the Supreme Court judgment. I do not see where they have deviated from the rules that we all know. But you see, they say 2 lawyers, 3 opinions. Everyone speaking will speak from their own area of bias. But I would say that it would be a bit stretched and, you know, a bit too much to refer to any of these judgments as a hijack.
Mr. Kachuku, the Labour Party says it disagrees with the Supreme Court judgment and described it as shocking. How will you react to that?
Well, the Labour Party has to say something to justify the humongous funds they received from the public. They have to take this as far as possible. They had to give them a reason to believe that they could win this. And as they have said, since they've not gotten justice from the Supreme Court, they are going to the Court of Public Opinion. And obviously, I'm sure they will still try and raise money from the public for this purpose. I don't believe at this point we should really try and belabor their opinion of what they are saying, because their conduct, as far as I'm concerned, was very dangerous to the safety and health of the Nigerian country, Nigerian nation. I believe our focus right now should be on how we can bring all Nigerians together to support our government to move Nigeria forward. Our issues still remain our issues. We wasted so much time on this court case. We wasted so much time educating this court case, both in the courts and also in the public spaces. But our issues still remain our issues. After the judgment was given today, we still have issues with our infrastructure. We still have issues with healthcare, education, security, and what have you. Our issues still remain our issues. What must we do right now to solve our issues? Today now, I expect that the president should now be presidential. He should now show he's the father of all Nigerians. If Atiku and Peter Obi refuse to congratulate him, There's nothing wrong with if the president decides to reach out to them, to visit them. So Nigerians can see that he's done everything humanly possible to bring everyone together. He needs all Nigerians to be on board to solve the critical issues before Nigeria today. So he must bring everyone together. He must talk to everyone, opposition, those on his camp, bring everybody together so that we can, as a nation, solve our problems together.
All right. So let me stay with you, Mr. Kachukwu. The judiciary came under attack over this election petition. What do you think can be done to check this?
Well, if I expect that the National Assembly should start looking at this. My late father was a federal high court judge, and I know how he felt about this institution. I was very sad when I saw what Nigerians did ignorantly to this institution. The judiciary is supposed to be the last hope of the common man, but the same common man disreputed this institution. They abased this institution. They debased this institution. They took this institution to the cleaners. They made clear to everyone that they did not believe in the institution and in whatever they will say. They made clear that whatever they will say was corrupt before it was even said. That is wrong. Because our democracy depends on the integrity of this institution, on the faith we have in this institution. So if we say to ourselves as a people that we have no trust, no faith in the judiciary, what are we standing on as a people? We might as well let a state of anarchy prevail, because the judiciary is supposed to uphold society, uphold constitution that frames society. If we say it does not exist, it is corrupt, we might as well let a state of anarchy prevail in Nigeria. So the National Assembly must look at this. What do we do to people who promote anarchy by disreputating the judiciary? What should we do to those people who consciously, who intentionally do things to make Nigerians doubt the integrity of the judiciary? What should we do to those people? This should not be allowed to happen. Tell you what, it's very easy for people to have taken those pictures that they saw all over the internet of our judges, gone after them, gone after their families. That's what they intended. What happened if people had done that, killed, someone had lost their life in this process? What do we then say to ourselves? I expect that the National Assembly should be looking at this critically and come up with a solution to this.
All right. Let me come back to the studio. I mean, just like, what do we do to people who promote anarchy by disrespecting the judiciary?
Well, in addressing that, I'll also come with another legal maxim that says that your right to your expression, to do what you feel you want to do, stops where my right to privacy and dignity begins. And I think that it's important that that point is driven home. Mr. Kachukwu alluded to certain things that were scary, really. You know, when you started seeing tweets of children, of justices, their addresses, you know, and then it began to look really funny, you know, because it looked more like an intimidation. We need to stem that in time. But, you know, when you look at how we have gotten here, like I've said, the weed and the chaff, the weed and the crop analogy. When you let the weeds grow, they kill the crops. When you allow ignorant information fester, they kill the right information. When people understand that there are rules and there are procedures, the question now would be to those who are representing their interest. Have you met the conditions precedent? Have you done all that you need to do to fight my cause? You know, don't come and tell me XYZ. Right? And I think that that information, when you pass across that information, everything that we're seeing today is a product of information and how it is flowing. Right? And so government must now sit down to look at, I'm not saying gag people, I'm not saying, you know, infringe on people's freedom of expression. But information to counter fake, false, misleading, or truthful information must now.
We're interrupting this program to bring you a live telecast. Our regular programs will continue shortly.
Thank you very much, Trinity Academy. The voice of the youths must be heard. Thank you very much. And without wasting time,
thank you very much. At this